Okay, my name is Jeff Morgan, and some people have been wondering what I did recently to get the State Commission for Judicial Conduct involved in a case. For those who don't know, I have filed a complaint against Justice Jack James. Justice Jack James, the Justice of the Peace of Precinct One in Rockwall County, Texas. And I will go into some of the things that I did at the beginning, why I did it, and what the result has been so far. So in November of 2016, I filed a small claims suit against my ex-wife, Deborah Wygant. The reason I did so was because a year prior to that, she went down to court and she lied against me while under oath. So she committed perjury. Now, Justice Jack James said, well, we don't know that it's perjury. You have to say alleged perjury. So I am alleging perjury against my ex-wife, Deborah Wygant. And as a result of that, it cost me an extra $3,766, and that's a very conservative number. It was more than that, actually, and it could have been a lot more than that had not my attorney decided to give me her weekend work for free. So it could have been over $10,000. But my ex-wife got up there and she testified to things that were not true. She said that she was a witness to things that she didn't see. She said one thing and then she turned around and contradicted her testimony later on. She thought she was going to get away with stuff, and then what she didn't know is because of her actions, the trial got extended a second day, at which point I brought in documentation, emails, texts, pictures. I don't know if there's pictures in that time or just the first time, but it was pretty much very evident that her testimony was at the very least not in accordance with what the texts and the emails and some of the other things were saying. So I ended up having to spend $15,000 during that trial, and it would have been less than that had my ex-wife not gotten up there and lied. And in addition to that, we had witnesses. There were 5 witnesses, 2 nurses. My stepson Matthew has 24-hour nursing care, and he has severe medical needs since birth. So the nurses were there, my wife was there, my beautiful wife Karen. Her youngest son, Chris, who was a good friend of my daughter, was there to testify on my behalf. Chris knew both of us, and he went down there. My daughter was mad at him. How could you do this to me? Well, because it was the truth. And anyway, so I was accused of... What had actually happened prior to this is that I had been watching my grandchildren, Cruz and Gideon Morgan, and Cruz and Gideon, love you like crazy, miss you. Haven't seen them now for 2.5 years. And partly this is due to the fault of Children's Protective Services and Children's Medical Center, Children's Medical Hospital down in Dallas. What had happened is my daughter took Gideon into the hospital when he had an infection, and it was the right thing to do, but because of the type of infection and everything else, the hospital called Children's Protective Services. And, you know, they are mandated reporters, but they get to hide behind the cloak of anonymity. They are allowed to report you, but they don't have to disclose that they have reported you. So guess who got blamed? Right here. And prior to that, I had told my daughter, be careful of Children's Protective Services. Children's Protective Services is not your friend. And to anybody who's listening to this, Children's Protective Services is not your friend. You don't need to let them come into your house. They do not act in your best interest in many instances. They do not act in the children's best interest in many instances. In fact, they act in the interest of themselves in many instances. But that's a different story for right now. But because of this whole thing that took place, I was accused of calling up Children's Protective Services, asked the caseworker, her name is Penny Hutchinson, to please come forward and tell my daughter that it had nothing to do with it. I talked with her. I called her at least 6 times over the course of a couple of days. She also talked with my wife, and she knew. In fact, the reason that the CPS did not do anything further is because she heard of what I and my wife were doing for the children, and she had no fears because the children were safe when they were with us. Anyway, my daughter Stephanie sued me. She accused me of... she filed a false police report against me, and she tried to get a protective order against me. She was trying to get me fired from a job. She was trying to get me thrown into jail, convicted of a felony. She wanted to erase me from my grandchildren's lives, is what she said. She's going to erase the memory of me from them. And none of this stuff I did. This is the crazy part about the whole thing. Children's Protective Services does not get credit for what my daughter did. they get their own blame, and Children's Medical Center should get their own blame. And the legislators who actually allow these things to take place, and they know it, and they don't change it, they get their share of the blame. And of course, everybody's going to be so innocent about this. And what happens is they end up destroying good families. They end up destroying very powerful relationships. I've testified against Children's Protective Services because of the destruction that they do. In Texas, what we did then to help the situation out, we just gave them more money. More money will fix everything. They don't reform the system from within, and Hank Whitman, who was the Commissioner of Children's Protective Services, made a promise to me that he would get back to me. He has never done so. It's been well over a year. Hank, I'm still waiting on you. The only reason I was able to get any relief is because I had a senator, Senator Van Taylor, who is now going to be running for Congress. And Senator Van Taylor, I will support you. Thank you so much for what you did. Senator Van Taylor put pressure on Children's Protective Services, and they wrote a letter that said I had nothing to do with it. But at that point, the damage was already done. It was 18 months too late. I had been sued. Cost me $20,000 to defend myself over nothing. And my ex-wife got up there and was going for an Academy Award in lying. Anyway, that's my opinion. That's my perception. There were some other people that knew the facts of the case who said something very similar, but this is me speaking for me, and that's all that I'm doing. So anyway, about a year and a half goes by after this case, and my daughter writes to me and says, "Dad, I'm sorry." She's apologizing, and I said, "So what are you apologizing for? You tried to throw me in jail. You know I didn't do anything. You know that none of this stuff happened, and you could have ruined my life. You could have ruined my marriage. You could have, I could have lost my job. My career could have been over. I could have had my whole entire life ruined because she got upset about something." And then she said, "Well," I said, you lied. You lied under oath, and your mother lied under oath." So she said, "Well, my mom didn't lie." And I said, the judge felt she lied. So what I did then, I thought, how do I show that, your mother lied. She lied. You know it. You lied. And your ex-boyfriend, Casey Wilson, he also lied, but I can't prove that because I didn't have documentation from him, whereas I had emails and text messages from both my daughter and my ex-wife, and other people on her side of the family. I had nothing like that in writing against Casey Wilson, who, by the way, later tried to kill Stephanie or threatened to kill Stephanie. But anyway, so what happened is I thought, how do I deal with this? How do I try to say, "Stephanie, you're wrong. Why are you keeping the grandchildren away from me? I was the one who was there for them, and you know this." And she said her mother didn't lie. So somehow I came up with the idea that, I can go to small claims court. It's small claims court. I can go there. I can present my case because my ex-wife cost me, I said, $3,766, and I itemized the bill. And so I went down to the I think her name is Kim Ralston. I'm not positive, but I think she's the administrative assistant for Judge Jack James. Judge Jack James, Precinct One, Rockwall County, or Rockwall, Texas. Remember that name because I have filed a complaint against him. And Judge Jack James, I'm hoping that you're watching because, yes, I did file a complaint against you. The way that you acted in that courtroom toward me is inexcusable. And I hope that you do get disciplined and reprimanded because you deserve it. Anyway, so I went down and I filed a small claim suit against my ex-wife. This was, I think it was November 30th of 2016, a little bit after Thanksgiving. So my ex-wife responded the following month, about 2 weeks later. I think she had 2 weeks that she had to respond or something like that. Her answer was that, it's a frivolous lawsuit. I shouldn't be responsible for his legal fees. He's this, he's that. Yeah, so we have a court date that's going to be coming up. At least so I think. I'm thinking to myself, it's a small claims court. It's going to be a couple of months. We're going to get this thing resolved one way or another. We're going to have our day in court. I'll be able to present my evidence. She can present her evidence. It wasn't so much about getting her convicted of a crime. That's not what I wanted to do. I wanted to just say, because I've been lied about and smeared so many times, I wanted to be able to have that justification to say, "Stephanie, I did not lie. You know it. Everybody knows it. The judges know it." But this got delayed and delayed and delayed. So finally come May, and again, I remember I filed the end of November. I've called up the office every so the judge's office every so often, said, "It's going to be scheduled? What's going on here?" So, "Well, we've got a lot of cases." And so in May they decide, they're going to schedule me. And I said, okay, the only time I can't do it is this 1 week in July because I'm going to be out of town. Any other time, would be fine. I said, okay, that'll be great. So they accommodated my schedule, and they sent both me and my ex-wife a letter. And shortly after my ex-wife received the letter, she says she has to go in and file for a petition, a motion to dismiss the case. And it was amazing. It took me, from the time I filed to when my court date was going to be, was 8 months. She wants to file for a motion to dismiss, and all of a sudden everything's in high gear. It's all like nothing. The court has nothing else to do but to but to hear her motion to dismiss. So what happened is these are the events that I'm describing, and the events that I'm describing here I wrote to the State Commission for Judicial Conduct, and they're in Austin, Texas. I can provide the address later on. I will provide it in the commentary beneath this YouTube video. And here's what I wrote. I thought, okay, I've got to keep it to 2 pages, at least no more than 2 pages. I want them to read it. I don't want them to get bogged down with everything. So what I wrote was this. On June 23rd, 2017, I, Jeffrey S. Morgan, plaintiff, and Deborah A. Wygant, defendant, appeared before Judge Jack James to hear Ms. Wygant's motion to dismiss, filed on June the 8th, 2017. Amazing. 15 days after she files, she's in court. Whereas I have to wait 8 months for my day in court, and I never got it. You'll see why. I filed the claim with the court on November 30th, 2016, well within the 2-year statute of limitations in the precinct in which Ms. Wygant lived. I was seeking recompense for $3,766 that Ms. Wygant cost me when she came to court and committed perjury to testify against me before Judge Regina Moore of the 256th District Court in Dallas County, Texas, on July 22nd, 2015, in which Judge Regina Moore found me innocent of all charges. And if you've ever been had accusations made against you in a case like where there's a protective order or restraining order, usually the judge rules against you just because that judge does not want to become famous in case the guy's guilty and he really did do it. And then he goes around and he kills somebody, and then everybody's going to say, they appeared before the judge and this judge let him go. Why did this judge do that? So the default in this situation, like it or not, is that the defendant is found guilty, especially if you're a man. You're going to be found guilty for the most part. But she found me innocent. So Judge Jack James, the Justice of the Peace, Precinct Number 1, Rockwall, Texas. You remember that name, Judge Jack James, Justice of the Peace in Precinct 1, Rockwall, Texas. I will be repeating that name quite often. Stated at the beginning of the hearing that this hearing was not about the case itself, but only on the motion to dismiss. He was not going to hear evidence on the case. Shortly after Ms. Wygant started to read the reasons for the motion to dismiss, Judge James asked numerous questions of me pertaining to my case, and questions regarding why didn't my attorney do something, and why didn't the judge do something, and other issues that I could not speak to simply because I am not them. I wasn't the attorney, I wasn't the judge. I don't know why they did what they did, but this is what happened. Ms. Wygant's response asserted that my case was, well, in the letter that she wrote to the court, she asserted that my case was frivolous and without merit. And yet when I tried to show the judge that my case was not frivolous and had merit, the judge would not hear my arguments. He let me respond to his questions, but he appeared hostile to me, and I feared I was in danger of him dismissing the case on multiple occasions. He appeared to be taking sides and to have his mind made up. Judge Jack James, Precinct 1, Rockwall, Texas, was aware that the entirety of my case pertained to the perjury and was based primarily on the transcript of the case, which was recorded by Donna L. Collins, certified shorthand reporter for the state of Texas, CSR 1086. Consequently, Judge James corrected my use of the word perjury and made me say alleged perjury. We don't know if it's perjury. It's alleged perjury. He knew what the charge was. Judge James said he would not be involved in a he said, she said argument, to which I responded, this is not a he said, she said scenario, but that I had a certified court transcript of the hearing. In other words, it was a she said versus she said. She was contradicting herself, fighting with herself. She was lying. One way or another, she was not telling the truth, or at least there was inconsistencies. Let us put it that way. Yet Judge James said he would not read the entire transcript. I responded that Ms. Wygant's testimony was only 18 pages, pages 23 through 41, yet he would not read that portion either. I had email correspondence with Ms. Wygant in which she threatened to get me imprisoned and fired from my job, as well as multiple additional pieces of evidence that Judge James would not let me present. Remember, this is the case for the motion to dismiss, so he's not going to hear any evidence. But wait till you hear what he did. Judge Jack James, Precinct One, Rockwall, Texas, stated that he had never heard a case like mine. Well, I told him I understood, but that did not mean that he should not hear a case like mine. It's a case. It's a legitimate case. The judge seemed to be looking for ways to dismiss the case without it being heard. I don't know how long he questioned me, but it seemed at least 30 minutes, and I'm not even sure that it wasn't longer than 30 minutes. But when you're under the pressure like that, firing question and I'm answering, and I'm afraid the entire time, the moment that he asks a question, if I don't respond, he's going to just dismiss it for some reason. At the end of his questioning, he said to me, "I've beaten you up enough." And then he addressed Ms. Wygant. I was shocked when he said that he had, quote, "beaten me up enough." Judge James had beaten me up enough. The judge, because, beating up a plaintiff and going soft on a defendant does not seem to be the neutral, objective, and fact-finding process that a judge should follow. He certainly could not be accused of beating up Ms. Wygant, that's for sure. And in no way could he be accused of beating up Ms. Wygant the way he beat up me, or attempted to beat up me. I was still standing, but yes, he was trying to beat me up. Judge Jack James, I've beaten you up enough. Ms. Wygant claimed that Judge James had no jurisdiction in the matter. Now, here we are at small court in the precinct that she lives in, within the statute of limitations, and Ms. Wygant claims Judge James has no jurisdiction in the matter. Though when asked by the judge, she could cite no statute to support her claim. She also claimed that even had she had committed perjury, the case should not be heard because she was not a party to the lawsuit, only a witness. She seemed to be saying that perjury is okay in the state of Texas. I was dumbfounded when I heard that. I'm thinking to myself, are you kidding me? She's saying that perjury is okay if you're not a party to the lawsuit. If you're a witness, it's okay to lie. The only question that the judge should have heard was, did he have jurisdiction in this case? Yet this issue was not addressed by Judge Jack James in his order to dismiss, because he sent an order to dismiss the case with prejudice. And he stated the court had heard testimony, having reviewed documents, and granted the defendant's motion to dismiss. Judge Jack James had one document, I think I provided him, and I think it was maybe 1 page or something like that. He refused to look at the transcript, and he knew, at least that was my allegation, and I had it right here, and I was willing to give it to him, that the transcript showed perjury. And he knew that it was based on alleged perjury, but he refused to listen. He refused to read that. He stated he would not read the transcript, and when it was pages 23 through 41, he still didn't know he's not going to take it. He's not going to waste his weekend. So in my opinion, the judge did not review the pertinent documents. By refusing to look at the certified court transcripts, he chose to suppress. I'm accusing Judge Jack James of choosing to suppress the primary piece of evidence to make the case. Texas Government Code establishes the Justice Court to conduct proceedings in a small claims case in accordance with the rule of civil procedure promulgated by the Supreme Court to ensure the fair, expeditious, and inexpensive resolution of small claims cases. In my case, this did not occur. I am asking, and this again, I'm still writing this to the State Commission for Judicial Conduct. I am asking for a full investigation into this matter and a full review of any video and audio tapes that may have been made. Constable John Benedetto was present in the courtroom for the duration of the hearing. I am willing to be questioned and to provide additional details regarding the matter. Everything that I have stated in this email is true to the best of my knowledge and recollection. And here is with a statute that I also included with it, section 27.060, and I think that this is up to date. It was hard to find out the dates for some of these things. Small claims. A justice court shall conduct proceedings in a small claims case as that term is defined by the Supreme Court in accordance with the rules of civil procedure promulgated by the Supreme Court to ensure fair, expeditious, and inexpensive resolution of small claims cases. And I wasn't trying to cost anybody extra money. I wanted to be recompensed for the money that it cost me, but even more importantly, I wanted it to be known that she lied, that she committed perjury, that she lied under oath, and that never got a chance to be heard. And the Judge Jack James, actually knew that that was the case. That's what my whole case was based on. B, except as provided by subsection C, rules of the Supreme Court must provide that 1, if both parties appear, the judge shall proceed to hear the case. Number 2, formal pleadings other than the statement are not required. Number 3, the judge shall hear testimony of the parties and the witnesses that the parties produce and shall consider the other evidence offered. Number 4, the hearing is informal, with the sole objective being to dispense speedy justice between the parties. Speedy justice, not injustice. Injustice, Jack James. Number 5, discovery is limited to that considered appropriate and permitted by the judge. And 6, the judge shall develop the facts of the case, not your opinion, not what you want, not what you hope, not what you feel at the time. And for that purpose, may question a witness or party. It doesn't say anything about beating up a witness, by the way, here, Justice Jack James, or beating up a defendant, a plaintiff. And for that purpose, may question a witness or party and may summon any party to appear as a witness as the judge considers necessary to correct judgment and speedy disposition of the case. So, I mean, the first thing I thought when I read this is that, if both parties appear, the judge shall proceed to hear the case. I don't know that should have happened here, but I have that question in the back of my mind. Both parties were there. Should not have the judge have just gone ahead and heard the case? Rather than hearing a motion to dismiss in small claims court, we were both there. I had to take time off of work in order to be there. Justice Jack James, Precinct One, Rockwall, Texas. I wrote this at the State Commission on Judicial Conduct, and I am thankful that on July the 14th, 2017, the commission wrote back to me. The next video, I'll talk about that. Thank you.